Good morning and welcome, and thank you for joining us for our virtual in-house counsel seminar. This is our second session of the day titled Kick into High Gear, Rapid Fire Legal Update. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Warden Smith, and I'll be the MC for this session. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar. We think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose side-by-side mode. The slide deck should appear on your left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of your view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. During this session, you will have an opportunity to answer a question via our polling software. Please note, if you attended our first session and participated in those polling questions, you do not need to opt in again. However, if this is your first session of the day, the opting in is easy. Take out your mobile phone and text the message in-house counsel, no spaces, no hyphen, to the number 22333. So again, you'll open up a new text message where you would put the phone number, you type in the number 22333, and in the message box, you type in-house counsel and send, and that will opt you into the polling software. I would like to take a moment to introduce all of our speakers. Today's speakers are Amy Wooten, Paul Fanning, and Mike McIntyre. Amy is a litigation attorney with a wealth of experience in a wide range of substantive areas. She litigates complex commercial litigation cases, construction disputes, community association matters and disagreements arising in the HOA context, professional licensing defense, and employment litigation. She also represents clients in a broad range of commercial matters, such as breach of contract, breach of fiduciary duty, and unfair and deceptive trade practice claims. Paul leads the firm's creditors' rights practice and is certified by the American Board of Certification and the North Carolina State Bar as a board certified specialist in business and consumer bankruptcy law. His practice experience encompasses bankruptcy, collections, creditors' rights, and lender liability. He concentrates his practice in the representation of creditors in complex bankruptcy cases and state court litigation, including workouts, collection reorganizations, and contested matters. Also joining us today is Mike McIntyre. Mike is Senior Advisor for Government Relations and Economic Development with our firm. Before joining our firm, he held the position of Congressman of North Carolina's 7th Congressional District in the U.S. House of Representatives. Congressman McIntyre has won top honors in Congress, including National Legislator of the Year for his work on behalf of veterans, National Legislator of the Year in Agriculture, National Legislator of the Year for Law Enforcement, and the National Leadership Award in Economic Development. Thank you all so much for joining us. Amy, let's kick off this rapid fire.
Thank you, Jen, and good morning, everyone. I'd like to say that I am very thankful that with my wonderful colleagues, Paul and Mike, on today, that I get to lead off, as they would both be very tough acts to follow. So thank you, Jen, for letting me go first. I'm going to spend some time this morning talking to you all about some of the trends we're seeing in litigation as a result of COVID and the move to a little bit of a more virtual world. So we're going to spend some time this morning talking about the virtual litigator. And, you know, we've certainly seen the use of virtual means and mechanisms in litigation before COVID. This is not an entirely new development, but we have seen a significant increase in the use of virtual proceedings in the context that you see before you: depositions, hearings, mediations, arbitrations, and of course trial as well. And we're going to spend a few minutes this morning discussing this trend of virtually litigating cases in each of these contexts and the significance that this shift may have for in-house counsel in each setting. So we'll start this morning with depositions. And in that regard, one of the things that we are seeing is with the shift to virtual and depositions being conducted via electronic platforms like Zoom and TrustPoint One and Veritex Virtual, to name a few, in-house counsel now have more readily available and cost-effective access to witness firsthand key fact and expert deposition testimony than they probably ever had before. And depending on the stakes in a given case, having this ability really could prove invaluable for in-house counsel in that it provides an opportunity to get a better sense of where the company's case is, where it may go in light of the strengths or weaknesses of the testimony of key witnesses. And it can also give you an opportunity to observe how corporate witnesses, especially key corporate witnesses, handle testifying. Maybe you have an amazing CEO or CFO who you would definitely not trade out for the world, and they're not very good at testifying. This move to virtual gives you an opportunity to evaluate that and put in place plans to address that for future litigation needs and opportunities. One other thing that we have seen in this shift with virtual depositions is a greater importance on logistics beforehand with these depositions. Virtual depositions are requiring a significant amount of forethought and planning. And in some cases, they warrant the entry by the parties of stipulations that will govern or serve as a roadmap for how the depositions are going to proceed to address concerns with witness coaching, proper exhibit sharing, and the like. If your company is involved in litigation often, it may find it helpful to have on hand a set of standard stipulations that you want your litigation counsel to present for consideration in a case. Having those ready will help save some cost and time in that process of working through those logistics on the front end, and hopefully can ensure some consistent standards in the cases in which your company is involved in when it comes to navigating virtual depositions. And on the cost savings part, while there is some added cost potential with the logistics being increased, there can be a significant opportunity for cost savings in that you're no longer having your litigation counsel, in some instances, having to go out of state or even across state for depositions. And in cases where there are a significant number of witnesses to depose, those savings can add up. So those are the key changes that we're starting to see arise in the shift to virtual in the context of depositions. And we'll spend a few minutes now talking about what we're seeing in the context of hearings. You'll see here the notation for a lost calendar call. In North Carolina state courts, traditionally when a matter is set for hearing, we go through a process called calendar call, and don't really have that necessarily in federal court, but we have seen in our state court cases that the days of calendar call and the inefficiencies that it brings, where you're packed in a room with your fellow litigators waiting for the court to tell you if your matter will be heard at all, and if so, when, are essentially gone in the courts that are proceeding virtually for hearings. Now what we're seeing is hearings are being set for a specific date and a specific time. And in many instances, parties are given fairly strict time limits because the court is often setting up back-to-back hearings and needs to be able to move on to the next virtual setting that it has set up. The fact that hearings are proceeding virtually, and while we have probably all experienced that tension between the difference in formality that can be perceived in the virtual setting versus in-person setting, certainly do not make hearings any less important when they're virtual. And in fact, I would argue we're starting to see that they are in fact somewhat more important, in that we're seeing a greater level of preparation by the judges. They have more often than not read the parties' submissions and already have in mind the questions that they have for your case. And while good briefing has always been important, the fact that we're seeing elevated attention from the judges at these hearings and an elevated knowledge base of your position really speaks to the fact that good briefing has become even more important in this context. And why does that matter for in-house counsel, the fact that we're seeing this elevated attention? Well, you all serve as the gatekeeper in many instances, or the conduit to corporate records. And so understanding and appreciating that our courts are devoting more time and attention to the matters presented may warrant thinking a little bit more about a particular strategy that you want to take in a case. For example, if you're thinking of withholding certain documents or taking an aggressive approach on discovery, you're going to want to make sure that you're comfortable with the extra scrutiny that approach may receive at a motion to compel hearing or some other stage in the case. One other thing that we're seeing with respect to the elevated attention in the context of hearings is more and more opportunity to land before the same judge in a given case. That's a departure from the norm for us in North Carolina state courts, where judges are not assigned typically to the life of the case, and the judge that you may have for your motion to dismiss hearing may not be the judge you have for summary judgment or for trial or any other motion in the case. In smaller jurisdictions, however, we are seeing an increase in appearances before the same judges who are going to have a greater familiarity with your case. And so setting out a good first impression in those cases and making sure you're preserving your capital with that judge is becoming more and more important. And then again, at the end there, we've got cost savings similar to what we discussed with depositions. There's certainly a potential for some cost savings in not having to travel to courtrooms or having a situation where you appear for calendar call only to be told you're not going to be reached that week and will need to come back at another time. Would like to go ahead and segue now to talking about some of the changes that we're seeing in the context of mediations. Again, there's greater access for in-house counsel to participate in that process directly in a cost-effective manner if that is something that is desired, with these virtual mediations becoming more and more prevalent. There is one potential hiccup that we have started to identify in virtual mediations that I think is very helpful and important for in-house counsel to be aware of and to work with litigation counsel in advance of a virtual mediation to ensure does not occur. And that has to do with how the company is going to sign a mediated settlement agreement if a mediation, if an agreement is actually reached at mediation. The North Carolina Court of Appeals issued an opinion in November of this year in which the court reversed a trial court's granting of a motion to enforce a settlement agreement. And the reason the court gave was because the settlement agreement had been signed by the attorney for the party against whom enforcement of the agreement was sought, and not by the party itself. The Court of Appeals concluded that having the attorney sign in lieu of the party violated the statute of frauds, and the court refused to uphold the settlement agreement on that basis. So with mediations proceeding virtually, it's really important to have a plan in place to ensure that a corporate representative with authority to sign a mediated settlement agreement is going to be available when that's needed, and that the logistics and manner of how that signature is going to occur have been worked out in the event that there is a settlement that is reached. Doing that will help eliminate or at least mitigate the risk of finding yourself in a situation where you're on the losing end of a motion to enforce a settlement agreement. I want to talk next about trial and arbitrations and some of the concerns that may be presented there in the context of a virtual world. I've not seen or heard at this point of any jury trials that are being conducted virtually in North Carolina at this point. I have heard of bench trials and arbitrations being conducted virtually, and it is unclear if we will get to a place where jury trials are being held virtually or through some hybrid in-person virtual format. And Certainly suspect that would raise some constitutional questions and concerns if we do get to that point. But what is one of the things that in-house counsel can be thinking about and planning for on the front end in an effort to avoid some of these questions? Well, you might want to give some consideration to including in your venue or forum selection clauses and contracts details or terms concerning whether arbitrations and hearings, arbitration hearings or trials can proceed virtually, or if they have to proceed live. And if so, there will, of course, be a question to what extent that clause may be enforceable, depending on the particular jurisdiction that would be asked to interpret and enforce that clause. But at the same time, it could offer some guidance on the front end for addressing that situation. All right. And then I have a question for you all. Would be curious to know of the matters that we touched on this morning, which would have the most interest for your company. Obviously, we kind of went through those quickly, but I think that, yeah, cost savings, definitely an important one. Well, I think the move to virtual here will definitely offer some opportunity to cost savings for companies. And actually, that's a very nice segue to the last tidbit of information I would like to touch on with you all this morning, and that's what's here to stay. If I had a crystal ball, I'd certainly be on a nice beach with clear water and an umbrella drink in the sand. And since I'm here, it's safe to say I'm not exactly Nostradamus. But my hunch is that as parties and their counsel continue adapting to virtually litigating their case, the cost savings realized from using virtual means to accomplish litigation and the greater access that it affords will be weighed against the benefits of going back to the way that it was. I suspect when that calculus is performed, we're going to continue to see virtual litigation above pre-COVID levels with more and more selectivity to what's going to occur in person. And I also suspect there will be greater receptivity by our courts to having proceedings conducted virtually, at least when it comes to hearings. I really appreciate your time this morning. It was a wonderful blessing to be able to share with you, and I'm going to turn our next segment over to Paul Fanning.
Thank you, Amy. I appreciate that. That was a great presentation and good segue in. I can tell you that in doing state court and federal court litigation, the state courts all but shut down for several months and only recently have reinstituted a process for having jury trials. That is not like the bankruptcy court. And the bankruptcy court is wide open and doing business as it always has been. That's important as I talk to you today about how to deal with vendors and customers that may be facing financial difficulties. Bankruptcy courts are open. They're doing business as if they were clicking along before the worldwide pandemic. The experts and the newspapers all expect a spike in bankruptcy cases, particularly business bankruptcy cases. COVID is not going to slow down the process, and you need to be ready for it. In fact, pre-pandemic, a new small business bankruptcy Chapter 11, Subchapter 5, designed to make the process more efficient and cheaper for small business debtors was put into place and took effect in February. The CARES Act increased the maximum amount of debt in those small business cases from $2.7 million to $7.5 million. That maximum debt limit expires in March, but I suspect we will see it continue. The advice here is pretty simple. You need to get ahead of the problems to avoid write-offs, and losses. Knowledge is power. No ifs, ands, or buts in anything business related. Knowledge is power. And the squeaky wheel gets the grease. You've got to be proactive in dealing with problems with your customers. If not, you'll lose your place in line. If you lose your place in line, then you're behind the next guy and the next girl who are squeaking a little louder than you are. And throughout this process, the trust factor with your customers and your vendors is paramount. So first thing we want to do is we want to look for signs that the customer or the vendor is in financial distress. The key to good collection practices and pre-bankruptcy planning is recognizing that your customer is having financial problems at all. Look to their historical payment or purchasing patterns. Are those changing in any way? These could include a customer's stretching of the time it takes to pay your invoices, changing in the payment method, submitting orders that are uncharacteristically large or small in quantity or value. Another thing to look out for is a sudden change in workforce, laying off employees, changes in senior management, hiring a chief financial officer or a chief restructuring officer. That's a telltale sign that the company is looking to restructure and may be having some problems. Finally, check for lawsuits filed against your customer, your vendor, other suppliers, and its customers. Google is an amazing resource, and the grapevine does talk, as I have listed in the PowerPoint. The second thing to do is to evaluate your relationship with the customer. Is this customer or vendor important to you? Do you need them for your business? If they go out of business or file bankruptcy, do you have a backup plan? To enable you as a business and you as in-house counsel to make informed decisions about the future of your relationship with these financially challenged customers, you first have to gather the information internally and externally from other sources. And importantly, you want to get accurate information from your vendor or customer itself. Many companies make it through distressful times without filing bankruptcy. The question for you is whether you want to be a part of it and participate in it. I will tell you that during the recession, our law firm had a lot of clients who went through financial distress. Working with them through that and working as a team player enabled us to establish and forge relationships that endure. That same concept would apply in your businesses, I'm sure. You need to be reasonable in if you work with and how you work with your customers. If they're going through financial difficulties, you want to reduce the risk, certainly, of a loss. But a trust factor is involved there, and you really want to understand the plan that is being proposed by your customer and understand the people and have confidence in them. First step in evaluating your financial exposure is looking at what's owed to you or the value of the goods and services and the impact that has on your business. Those are important to look at and really understand. The next thing to do is to take a look at your agreements, if you have one. Look at your contracts with these customers or vendors. There are a few questions that you should consider when you're doing that. One, what do the terms look like? How do they compare with market terms today? Can you enhance your deal in the contract? Do you have leverage at this point in time to change the deal a little bit to enhance the terms, but make it less risky for you. Another thing to look out for is, does your customer have alternative sources from which it can get the same goods or services? Or do you have other sources, alternative sources? These are all going to play in the profit concept and reduction of the risk. Another thing to look at is, are you contractually obligated to continue to do business with the customer? If you are not, or if you can change the contract to provide termination remedies, now's the time to do it. Another concept is the payment terms. And we have seen recently sellers of goods and other companies move from a sale of goods to consignment of goods. Let me explain that a little bit. When you sell a product to a customer on terms, on delivery, typically, they own that good, and it's difficult to get it back. But under a consignment relationship, if you changed it to that, you would retain ownership, and the ownership wouldn't change until an end customer buys that product and pays for it. That's one way to minimize the risk associated with doing that type of business. Again, the grapevine speaks, and you want to understand your industry. You want to ask other suppliers and other clients about their opinions and their willingness to continue to work with your vendor. You want to be careful about sharing financial information with other people. These are commercial transactions, so it has a little less scrutiny than consumer or retail transactions. But you don't want to find yourself intermingling with the contracts with other parties. All right. There are other remedies that you can consider when you are faced with some problems. Changing the payment terms we talked a little bit about, but paying in advance or on delivery is a change that might get you paid quicker. Setting up different forms of making sure that performance is there by your customer or your vendor. Concepts are listed in the PowerPoint: a deposit for your benefit, or escrow for your benefit. Even better than that is a letter of credit that can be pledged or posted for your benefit in the event of a breach or a particular event. And a surety bond would serve a similar purpose. All of those have their own requirements and their benefits and risks. Let's talk a little bit about something that is dear to my heart, and that is bankruptcy. Next slide, please. The bankruptcy code is alive and well. As I stated before, the courts are doing business, albeit sometimes virtually, sometimes by telephone, but they are not slowing down whatsoever. First thing you need to know about a bankruptcy is the application of an automatic stay. When a customer or any debtor files a bankruptcy, that puts a freeze on everybody, all creditors, any efforts to collect against the debtor or its property, wherever that's located. There's an automatic stay. If you violate that automatic stay, you can get into real trouble. You can be sanctioned, and the dollars can amount to a pretty stiff penalty. The purpose of a bankruptcy stay is to make sure that the status quo is kept, that the creditors who are seeking payment no longer are able to exercise their rights. That's everybody. It's meant to give the debtor a breathing spell so that it can restructure its business, restructure and rework the contracts that it has, and propose a reorganization that works for all creditors. You got to be aware that there are a lot of deadlines in bankruptcy cases. It is a big undertaking. It involves typically a lot of different parties and a lot of different interests. Among the deadlines that you really need to be aware of are, number one, the filing of a proof of claim. If you fail to file a claim in a bankruptcy case by its deadline, then you don't have a claim anymore. There are exceptions to that, but for the most part, you're out. And those deadlines are pretty stringent, typically 90 days from the filing date. So you never want to miss that deadline. The second deadline that really is of paramount importance is the deadline to object to a plan of reorganization. When a debtor in bankruptcy proposes a plan of reorganization, it is basically a modification of all of its contracts and all of its loans, and it's meant to restructure all of their deals. If you don't object to the treatment of your contract or your deal or your claim in a timely fashion, then you can, your rights will be lost. That's why it's very important to understand what the bankruptcy code provides and what it doesn't. You need to exercise your rights, and you need to, in a lot of cases, hire counsel that is knowledgeable about the bankruptcy code in order to assert those rights, or they will be lost. One favorable benefit of the bankruptcy code for debtors is the right to do things with executory contracts. The executory contract is a contract where obligations are owing from one party to the other and vice versa. That's what makes it an executory contract. There's still performance due from both parties. In bankruptcy, a debtor generally can assume a contract, which means they assume it, the whole contract, they continue to be bound by its terms, and they keep on paying or performing. The second thing is a rejection. They can reject the contract out of hand, which would leave the other party, the non-bankrupt party, with a claim for monetary damages. The debtor would no longer be required to perform under the contract. That's a rejection. Another alternative for a debtor, a power, if you will, is that the debtor can assume and assign an executory contract, which means they assume it and then assign it to a third party. And that's a third party that you didn't contract to do business with in most cases. There are some protections that are in place that require the third party to prove or provide adequate assurance that they can perform under the contract. But it is a huge departure from the contract that you'd entered into because you didn't willingly go into business with that party. Another thing to do when a bankruptcy case is filed is separate your accounts between pre-bankruptcy and post-bankruptcy. In a bankruptcy case, pre-bankruptcy claims or money owed is treated a certain way. Post-bankruptcy claims or debts are treated with a little more priority, a higher priority, oftentimes at the head of the line. And so it's smart for you to separate between pre-bankruptcy and post-bankruptcy. The right of set-off the right to net out what you are owed and what the debtor owes to you and what you owe to the debtor. The right of set off is preserved in bankruptcy, but you can't take advantage of that unless you have court approval. And it doesn't apply when you have a pre-petition claim and you're trying to set off against post-petition assets in most cases. So that is something that you really need to understand. Finally, the bankruptcy process is designed to be consensual in nature. It's designed so that the debtor is working with its partners, its creditors, in order to come up with a fair and equitable restructure. Negotiations are important, and how those negotiations are carried out and implemented make a big difference. So be aware that there is a strategy associated with that negotiation, and you need to take full advantage of the rights that are given to you under the bankruptcy code. So that's a primer for how to deal with vendors who are financially distressed. I hope you take something away. I wish I could see all of your smiling faces at the Umstead this year, but unfortunately that is not to be. I want to introduce to you our next speaker, Mike McIntyre. Mike, how about taking it away?
Thank you very much, Paul. It's good to be with you. And I want to also thank all of those on the panel, Jen for the great job in putting this together, and also Amy as well. And thanks to all of you who are joining us today. It's really special you would take time during this busy holiday season to take some time out to join us. And boy, has it been a busy time going from Election Day all the way to New Year's Day. And so we're going to jump right into this in the remaining time we have and catch you up on some of the things that have happened and hopefully put it in perspective. First of all, I think it's major to note that North Carolina set an all-time voter turnout record, 75.35%. So yes, we were over 75.33% for voter turnout. That has never happened before. By comparison, the 2016 election was at 69%, 2012 was 68%, and the first Obama election in 2008 was at 70%. So we have exceeded all of those numbers. As all the major polls predicted, Roy Cooper, of course, was reelected by a comfortable margin as governor, a little bit tighter than some of the polls that early on predicted, but nevertheless, we know that that evening by 11 o'clock, the Lieutenant Governor Dan Forest conceded that race. The other races, though, tended to be a different story. All 170 North Carolina House and Senate seats, of course, were up for grabs, as they are every 2 years. About 6.9 million, nearly $7 million was spent in broadcast advertising on the state Senate races, while about 2.5 million, 2.4 to be more exact, was spent on the state House races. The net results, the Republicans lost 1 seat in the state Senate, which means that the Republican majority is maintained, 28 Republicans versus 22 Democrats in the 50-member state Senate. And then in the state House, the Republicans had a net gain of 4 seats, bringing the total there to 69 Republicans and 51 Democrats in the 120-seat state House. So what this means is the Republicans will still have the majority in both houses. It will be the 6th consecutive biennium that we will have Republican control in both chambers of the state legislature. However, it is interesting to note that, as was the case this past 2 years, neither of these Republican majorities rise to the threshold of veto-proof supermajorities. So what that means is that, once again, if the governor vetoes a bill, there is not an automatic override at all by a supermajority. So it'll lead to probably further discussions and further negotiations between the governor's administration, obviously, and the state legislature. But it's interesting because in North Carolina, being the state that it is, it's a state that can go either way in these statewide elections. What made a difference this year? Quite honestly, there was a lot of prediction ahead of time that the state Senate would probably be the body that would be up for grabs, or it would be so close that the lieutenant governor's race would be a major difference because the lieutenant governor presides over the Senate and can vote in the event of a tie. However, that, as we know, did not happen. So the political dynamics will remain largely unchanged. We do know one of the first issues that will have to be dealt with is a projection of about a $2 billion revenue shortfall as the numbers come in finally for what occurred this year and last year, and as the state legislature begins its work in January. On the Council of State races, as indicated, the lieutenant governor's race drew some extra attention, not only because of the closeness expected of the state Senate races, but also because of the fact that it would give North Carolina the first opportunity to elect an African-American to serve as lieutenant governor, since both major parties had African-American candidates. In the end, of course, Republican Mark Robinson won the lieutenant governor's race 52 to 48% over Democrat Yvonne Lewis Hawley, becoming thus the first African-American lieutenant governor in North Carolina's history. The incumbent, Josh Stein, the Attorney General, also was reelected, had a close race, but not close enough to call for a recount. And then compared that to incumbent Republican Steve Troxler, the very popular Commissioner of Agriculture, handily won re-election. With regard to the Court of Appeals and Supreme Court races in North Carolina, unlike what happened in 2016 and 2018, this time Republicans swept every contested race for the state's appellate courts. As we know, the numbers are still being counted on a second recount as we speak in the Chief Justice race between Cherry Beasley and Paul Newby. And we'll have more on that in a minute. In the other major statewide races, Phil Berger Jr., who's the son of the Republican leader in the state Senate, won a seat on the state Supreme Court. Republicans now have a majority on the Court of Appeals and a closer balance on the state Supreme Court, 3 Republicans and 4 Democrats. So it does keep North Carolina, once again, a state pretty much in the center. And what that means is that getting out the vote made a big difference. A lot of the strong Republican turnout was attributed, of course, to President Trump making several visits to North Carolina as a battleground state and driving that turnout all the way down to local races. There was a great increase in the number of folks that were voting, and obviously a great increase in terms of the Republican performance in those votes. In the U.S. Senate race, which obviously garnered much national attention, is considered to be one of 4 key U.S. Senate seats to help control the U.S. Senate. We know that Cal Cunningham, of course, lost to the incumbent U.S. Senator Thom Tillis. It was the most expensive Senate race in our state's history and in the country, $282 million. So it was a whopping amount of money spent on that race, sometimes 3 and 4 ads within a 30-minute period if you had the television on, just devoted to that race. Congressional races all went pretty much as predicted. There was a strongly contested race between incumbent Richard Hudson and Pat Timmons-Goodson. Pat Timmons-Goodson, of course, had served on the state Supreme Court. And there was about $11 million spent on that congressional race. About $6 million was spent on the race for what was former Congressman Mark Meadows' seat out in the Asheville area. Of course, we know that he is serving as chief of staff now to President Trump and resigned that seat. So that had a great attention too as an open seat. It's also interesting to note that in the statewide races, there were 15. The Republicans won 10 of those seats. Excuse me. The Democrats won 4, governor, attorney general, secretary of state, and auditor. And then, of course, there's one that is still subject to a second recount, and that's for Chief Justice between Paul Newby and Cherry Beasley. Governor Cooper's advantage, of course, his popularity, as well as the COVID-19 crisis, obviously gave him great exposure in terms of the work that he was doing. The lieutenant governor's race, there was about $8 million spent, much more by the Democrats than the Republicans. Bloomberg dropped, it was estimated around $2.5 million into that lieutenant governor's race, one of the races he chose around the country to put money in. But most of that money was spent on just acquainting voters with Yvonne Lewis Hawley. It did not really contrast Hawley with Robinson. And so that made for an interesting result because people thought that race would have been closer. Also, when we think about the turnout for voters, a lot of people question why weren't the pollsters right? We know that they really messed up in the Hillary Clinton-Donald Trump race 4 years ago. And of course, there are a lot of those pundits who say, well, there are different things to point to. One has been said that a lot of times voters in rural areas and a lot of the Trump supporters tended not to respond to pollsters on telephone interviews. And of course, that's the main way that a lot of voters are reached during these polls. Also, another difference was minorities slightly voted more for Trump than they did 4 years ago. Not a lot. Of course, by far, Biden overwhelmingly carried the minority community. But there was an increase. Statistics show among African-American men went slightly higher than it had previously for Trump, but obviously still overwhelmingly for Biden. But then another change in terms of how the polls were working is that the unaffiliated voters are hard to poll. A lot of unaffiliated voters, by definition, don't want to be pegged or don't want to forecast what their vote's going to be. Many unaffiliated also want to wait a little bit closer to election day to engage and make a decision. So all of those factors are ones that others have said may have influenced why the polls were not accurate. On the state Senate race or the state General Assembly, the real focus by the Democratic Party was on the state Senate. As I said, most people thought that that was a potential flip. And so the Democrats far outraised and far outspent the Republicans on the state Senate races. But it turns out that in retrospect, it was probably too much too late. You would say too little too late. Well, they spent a lot, but it was too much, but too late. It would have been helpful if it had been earlier in the summer, because by the time the more contested state Senate races came to the viewer's eyes on TV ads and on social media, most of those races, the opponent had already been painted. The Republicans obviously did a good job in advance media blitz by targeting certain races and painting the opponent ahead of time, so that by the time the national Democratic money came into some of those races, it was too late. And so most of those races went in a way that did not really cause a major change, obviously, as we said earlier in the General Assembly. A couple of Senate races of note down in Wilmington, that was not a typical race that could be analyzed because it was more localized. Senate District 9, Harper Peterson, former mayor of Wilmington and the current state senator, was defeated by Michael Lee, who was the former state senator, the Republican. So that was more of a local battle focused on the personalities of those two individuals and each and their own records locally. And so that was interesting. President Trump lost that district, but Republicans won it because of the state Senate race. Another race that was interesting was a rematch between Wesley Meredith and Kirk DeVere in Cumberland County. Kirk DeVere held on to that seat as a Democrat. And then yet another interesting race was in Alamance County, which was being more and more influenced by the growth on the west by Elon and Greensboro, and on the east by Chapel Hill and Orange County. And that was a flip from the incumbent Stephen Ross in House District 63 to Ricky Hurtado. So there are other races, of course, that were interesting to watch, but those were some of the key ones, or that kind of give an overall idea of how things went that night. In looking at the federal situation, the U.S. Code provides that election results, if they're contested in any state prior to election day, and if that state has enacted procedures to settle controversies or contest over the electors or the electoral votes, and if those procedures have been applied and the results have been determined at least 6 days before the electors meet, then those results in that state will be considered conclusive, and they will apply to the counting of the electoral votes. So what all that means is there's a safe harbor deadline, as it's called, that states have a certain limited period of time to follow procedures that they should already have in place. And if they follow them, and then a final decision is made in that state, then those results are respected as long as they're made by that date. And this year, that date is December 8th. It's not far away. That is the date. Why chosen? Because it's 6 days before the electors meet. And the date of December 14th is when the 538 members of the Electoral College will meet in their respective state capitals in the District of Columbia to vote by paper ballot. One ballot for president and one for vice president. So the electors will meet, and then those ballots will be counted in Washington at a joint meeting on January 6th of the Senate and the House at 1 p.m. They will meet in the House chamber, and the vice president will come over and preside in the House chamber, which is interesting, that dynamic. And if the ballots are counted for the electoral votes and either one of the tickets receive a majority of 270 or more, then the vice president will announce the result, and that is deemed a sufficient declaration of the persons elected as president and vice president. Now, if anybody wants to object to those electoral votes, it'll have to be a member. It'll have to be at least one member of each body. At least one senator and at least one member of the House would have to object in writing. And if that happens, then the joint session meeting in the House on the House floor would recess, and the two houses would separate, and they would debate the question of the challenged electoral votes for a maximum of 2 hours. And then after those 2 hours, each house has to vote separately on whether to accept or reject the objection. An objection to a state's electoral vote must be approved by both houses in order for any contested vote to be excluded. That, my friends, will probably make it an unlikely scenario, because as it stands now and as is predicted now, the likelihood is that there will be a Democratic majority in the House and Republican majority in the Senate. So it's probably unlikely that both houses will agree to exclude electoral votes. An electoral vote will only be excluded if both houses agree. So it would probably have to be pretty egregious for that to happen. Assuming that that process does bring to a conclusion the election, then on January 20th, as set by the Constitution, the president and vice president will be inaugurated. The vice president takes the oath first, followed by the president at 12 noon. And that'll be the technical beginning of the new administration if everything goes as is currently predicted. As we look back to the elections, the Republicans defeated 9 incumbent House Democrats. The House Democrats were able to flip 2 open seats in North Carolina and 1 open seat in Georgia. All of those seats currently held by retiring Republicans. So those were open seats that were up for challenge. In North Carolina, of course, Deborah Ross won a congressional seat in the Triangle area, and Kathy Manning won a seat in the Triad area. So North Carolina will have 2 new representatives serving in the United States House of Representatives. Also, with regard to the control of the chambers, the Democrats, of course, hold a majority in the House. That means they will continue to control chairmanships of all 22 standing House committees. In the majorities, the majority party that wins is entitled to have a majority on each of the committees and their subcommittees. The top 3 positions will be maintained as it appears. That means Nancy Pelosi, Steny Hoyer, and Jim Clyburn will be the top 3 in the Democratic majority. And it also means that the Republicans, of course, as minority, will be retaining their same elected top 3. They have chosen, once again, Kevin McCarthy, Steve Scalise, and Liz Cheney. So those will be the leadership, all familiar faces and familiar names. Now, congressional committee assignments, of course, are decided by the policy committee of each party's caucus as to who serves on what committee. There are 3 open House chairmanships, appropriations, agriculture, of interest especially to us in North Carolina, and foreign affairs. So you will see 3 new chairmen. Otherwise, the other chairmen of all the other committees in the House are expected to remain the same. With regard to the ranking members, which are the top members of the minority party, there are going to be several open seats and several changes, too numerous to name in the time we have here, but look for some major changes in the top ranking Republican on the House committees and subcommittees. Over in the Senate, we know that the 3 incumbent senators that were running for re-election were all defeated: Senator Doug Jones of Alabama, Cory Gardner of Colorado, Martha McSally of Arizona. That resulted in a net gain of 1 for the Democratic Party to go from 47 to 48. Now we know that in Georgia, because neither one of the candidates for the US Senate received a 50% majority, which they're required to under the way Georgia's law is written, that will have a runoff. And until that runoff is determined on January 5th, we will not know for sure who the majority party will be. But if either one of the Democrats lose, then the Republicans will have the majority. So both Democrats would have to win in order for there to be the chance for the Democrats to control. That would mean there'd be a 50-50 tie. And of course, in the case of a tie, the Vice President, Kamala Harris, in this situation would be the tie-breaking vote. So that would give the Democrats the majority vote if that happened. But for that to happen again, both Democratic candidates in Georgia would have to win their respective Senate races. The Senate Republican leadership, Mitch McConnell, will continue to head up the Republicans, and the Democratic side, Chuck Schumer will. There will be several new Republican leadership positions that come open as far as Senate committees go. Again, too many to name here. There's only one new Senate committee leadership position for the Democrats. And that's going to be Senator Brian Schatz of Hawaii, who will serve as the Democrat ranking member on the Indian Affairs Committee. When we think about all this and what it means, I'm reminded of some of the words that I heard Professor David McLennan of Meredith say, that North Carolina is still a southern state. I thought his analysis was interesting. He said, unlike Virginia, which is moving to be more reliably Democratic in its votes, North Carolina is more like Texas. It's a center-right state. We tend to vote in the center, but lean slightly toward the right, which is what you see in the results of many of the statewide elections. What to expect in Washington? We'll continue to have a divided government, but that's not new. We've had a divided government since Carter was president. Most people don't realize that, which means that there will be give and take. It'll be a different Congress, though, than what Joe Biden remembers when he served, because there are more Republicans and Democrats have retired. So there'll be a lot of new faces on the Republican side. And then the Republicans are even more conservative, and as a whole, the Democrats more liberal because of redistricting and how the party lines have been drawn. Most of the seats, as we know, in the US House are up for grabs in the primary. So the issues that are going to be faced, from racial justice, climate, coronavirus, consumers are different. We know that advertisers get involved now, corporations get involved in affecting issues. The debates over economic packages, healthcare, employer-employee relationships, adequate broadband, especially to rural areas and with students having to study virtually, paid sick leave, issues like prison reform, police reform, economic disparity, especially between rural and urban areas. These are all going to be issues up for grab. The main thing, of course, that's going to control all of this is going to be the pandemic. So the real estate of the common ground is so valuable that there will be a lot of negotiation over what will be built upon that common ground. That's what makes politics interesting. That's why politics is the art of compromise, so that there can be a movement forward in our nation. I know with time expiring, I just hope that all of you enjoy your holidays. We can rejoice as a nation that we do have a peaceful transfer of power. And as we reflect on our families in this special time of year, I hope that we'll all renew ourselves for the challenges we face as a state and nation in the future. That's what elections are about. Enjoy your holidays. And as Tiny Tim once said in A Christmas Carol, may God bless us, everyone. Thank you very much.
Thank you so much, Mike. And thank you to Paul and Amy for presenting today. For those of you in attendance, you will be sent an email with a recording of this session. As I mentioned in our first session this morning, I have been in contact with the North Carolina State Bar Board of Continuing Legal Education and was informed that their CLE review process has slowed a bit due to the pandemic. Because of this, our CLE pre-approval application for this session is still pending. However, upon confirmation of program approval, Warden Smith will submit accreditation materials for attendees seeking North Carolina CLE credit only. If you need out-of-state CLE, please email us at rsvp@wardensmith.com to receive a certificate of attendance and webinar materials for submission. Thank you again. This concludes our second session of today's virtual in-house counsel seminar. Our third and final session of the day will begin at 1 p.m. Thank you. That concludes the session.